Good morning, everybody. My name is John Borowski. I'm the Vice Chair of the Eugene City Planning Commission, and we are here today for our regular meeting, and the topic is going to be deliberations and possible action on the Oakley Co-housing PUD remand, PDT 13-1. Commissioner Taylor is ill today, so I'll be acting as chair. And with that, I'm going to turn it over to staff for a few procedural items, and then we'll get going into the presentation.
So before Eric gets started, I wanted to say first, I'm Emily Jerome. I'm new to this project, kind of. I'm well versed in the materials at this point, but Ann Davies had been the attorney staffing this matter. She's no longer in the city attorney's office. I'm pinch hitting on this one. But we actually have hired a replacement for Ann Davies, who's Lauren Summers, who is also here sort of by way of introduction to you. She will be handling most land use application matters from here on out. And so asked her to be here, and you guys can, she may have some things to add today as well. Before we talk about any of the substantive issues today, I did ask Commissioner Randall to come to address the Planning Commission in person very soon after we notified the Planning Commission that the Oakley Meadow PUD would be coming before the Planning Commission again. Commissioner Randall contacted us and informed us that he had a conflict of interest and would not be participating. So he, on April 17th, wrote an email out that went out to all of you and was placed on the record. It's at page 334 of the record, that explained his conflict of interest. But in an abundance of caution, I also asked him to come and put that conflict of interest declaration on the record. So Commissioner Randall, if you could come up and state your conflict. And then I've also asked, and he has agreed to, after he reads this, he's just simply going to leave the meeting because he doesn't need to be here anymore.
Okay, thank you. Well, I'll just read pretty much what I sent out. On October 5th, 2015, the Planning Commission made a final decision on the Oakley Meadows co-housing application for a tentative PUD, PDT 13-01. On October 23rd, 2015, my architectural firm was contacted by Oakley Meadows Co-Housing LLC to ask if we would be interested in providing architectural services related to the development. Prior to October 23rd, 2015, neither I nor anyone from my firm had any contact with anyone from Oakley Meadows about doing work on that project. On November 10th, 2015, my architectural firm agreed to work with Oakley Meadows Co-Housing LLC. During that November 10th, 2015 discussion, I made it very clear that going forward, I would not be able to participate in any Planning Commission deliberations or decisions regarding the Oakley Meadows co-housing tentative PUD application. The Planning Commission's decision on the tentative PUD has gone through a series of appeals, so the Planning Commission has not deliberated or acted on the Oakley Meadows applications since October 5th, 2015. However, the Planning Commission's decision on the tentative PUD application was recently remanded to the City, and the Planning Commission will be asked to deliberate and make a decision on the application on remand. Therefore, pursuant to ORS 244.120, Eugene Code Sections 2.333 and 9.7065, and the bylaws of the Eugene Planning Commission, I am hereby declaring an actual conflict of interest with respect to the Oakley Meadows co-housing tentative PUD application PDT 13-01, and I will not participate in any further discussion or decisions on this application. Thank you.
Thank you. Goodbye.
Bye.
All right.
Thank you.
You bet.
So before Emily gets into some more procedural items we need to take care of before the Planning Commission discusses the substance of it, I just want to give a quick introduction, kind of background for anyone watching, or just a reminder of the history of the project. So as you all know, the hearings official approved a tentative PUD in 2013. It's the Oakley Co-Housing tentative PUD. It's file number PDT 13-1. The hearings official approved that in November of 2013, and then on appeal, it went to the Planning Commission. The Planning Commission conditionally approved that. Since then, it's been up and down through the Oregon court system, and the Planning Commission has seen it twice by now. And what happened during the 2015 Planning Commission hearing was that the record was reopened during, and adequate notice was not provided to parties. And so the court remanded that based on that. And that's what brings us to the current remand deliberations today. And so what we did over the last 2 months is we had a series of open record periods that allowed all parties to submit new evidence and testimony related to 3 issues that we outlined. And those were the right-of-way width of Oakley Lane, the pavement width of Oakley Lane, and parking on Oakley Lane. And so that's what the purpose of this last open record period, which you've received all those materials, is to let all parties submit evidence and testimony related to that. And so today, our staff will be available to help point you to new things that have come in the last couple months and clarify anything. There is a lot there, so I can't say that I know where every single thing is in the record, but I will do my humanly best to try to direct you. And I think Lauren and Emily and Alyssa will also be able to help on that some too. So that's all I have to start, unless there's any immediate questions.
Do any of you have questions about why or how we chose the items, the specific scope of the items that we opened the record for?
Yeah, sort of.
So what we did is take exactly what you opened the record for last time and got in trouble procedurally for not opening it to everybody for that purpose. So we intended to put all the people out there in the same position as those who were able to, who had notice of and were able to provide material in the record. So we carefully listened and to the meeting before and wrote down exactly what the record was open for before and provided that opportunity. Is that?
Commissioner Baker.
Yeah. The Court of Appeals decision stated access safety issue for which the record was reopened.
Right.
There's been some discussion in the record about that's not limited to the 3, necessarily to the 3 items that you discussed. It could be broader. It could be any access safety issue related to that. So I wanted to understand why you narrowed the criteria from what the Court of Appeals stated.
The Court of Appeals kind of used a shorthand that it took from Luba's decision, and they began calling it the something access safety or safety access as sort of a shorthand. We went back to do exactly what you did, to choose your words exactly from what you had articulated in the previous meeting when you reopened the record. And it's clear that's what the court intended. They just didn't every time they mention it. They kind of created that shorthand terminology of access safety, which I don't think is a term you guys ever used.
Yeah, my only concern is that we had some judicial decision-making on this, that we don't make decisions early on that may prejudice the case, so then we'll get to another point in time, where we have a similar remand. So that's why I have some concern about. I don't know that necessarily what the 3 categories necessarily limit it, but that's my concern.
Yeah, and I share that concern, and I'm hoping that we'll never be in this particular procedural posture again. I will say that and we'll talk a little bit more about it, but the folks who participated were very, very mindful of the notice, and we actually didn't have issues where we felt like staff or legal, there was anything in the record that went beyond that. So fortunately, I think that the participants have played quite fairly and good, and that it's not going to be an issue in this one. So I'm appreciative of that not being an issue for you, I don't think. So, but let's talk about a few more things. Procedural legal things I want to get out of the way first. If Commissioner Taylor had been here, I would have gone into this in more detail, but I do at least want to address the fact that on page 337 to 358 of your record, Paul Conti alleges and challenges the impartiality of Commissioner Taylor. He alleges that she's biased in favor of the applicant and argues that she should recuse herself. I want to note for the record that Commissioner Taylor is not here today, but it's because she's ill, and it shouldn't be construed as a recusal. She has not recused herself and has not been able to address the challenge. So nonetheless, her absence makes it a non-issue today. I just wanted to make sure that it's clear that her absence isn't implicit admission of any sort of impartiality or inability to be impartial, excuse me. So I do want to talk a moment, though, about bias generally, because the record is full of allegations of bias. And I want to make it clear that participants in any quasi-judicial hearing are entitled to an impartial tribunal. It doesn't mean that you have to come to the table completely free of any preconceived notions or bias. What it means is that you have to be able to put any such thing aside as you're making a decision. So you have to engage in your fact-finding, and be able to interpret the code and apply the code criteria to the facts and result in an ultimate decision that does not reflect any sort of bias that you may have. So you have to be able to be fair and impartial, and you have to actually practice fairness and impartiality in your actions. So, you know, in this case, because you've evaluated this particular application twice before, I think it's hard to come at this without any sort of ideas about the application before you get to the table. And so for that reason, I wanted to make sure that each of you is open to the possibility that the material that have come in this 2017 process could change your mind or lead you to a different conclusion than whatever one you individually reached during the earlier proceedings. And, you know, it's unusual that you've seen it before, and for that reason, I just wanted to give each of you the opportunity to declare on the record that you can be fair and impartial. And so now would be a great time to do that. You don't have to say anything more than that, but I think it's useful and important for the participants to hear that you can be fair and impartial.
Okay, well, I'm the chair, and I believe that I can be fair and impartial in this hearing.
Stephen Baker, I believe I can be fair and impartial in this hearing.
John Jaworski, I believe I can be fair and impartial in this hearing.
Jeff Mills, I believe I can be fair and impartial in this hearing.
Brianna Nicolello, I feel that I can be fair and impartial in this hearing.
Thank you for that. And then I want to move on to the fact that that Mr. Conte has also accused planners and legal staff of being biased and intentionally representing testimony and facts in the record. And from a legal standpoint, I want to tell you that whether or not you believe that allegation is a matter of your own concern, the law is clear that the Planning Commission is the decision maker here, not staff. Even if staff have a blatant bias, that's not a sufficient basis for LUBA to overturn a decision. It's up to you. The Planning Commission has to decide if they think that information or a memo or anything given to you by city staff is not reliable because of a bias that you believe staff person has, then don't rely on it. Rely on the other thing in the record that contradicts it. That's your prerogative. So if you find that something in this record is unreliable because you think it comes from a place of staff bias, you must identify the contradicting material in the record that you find more reliable, and you should explain, you know, which one you're relying on and, you know, why you think the other one is the most reliable. And so I just want to tell you that I'm not even going to address whether or not there is a staff bias. If you think that it's there, your job is to wade through the information in the record to weigh the evidence with that in mind. This does lead me into some record objections that we do need to talk about. So the record in this case actually includes the entire 2013 decision-making process. Did you guys bring all this stuff? Oh, yeah. There it is. The record from the 2015 decision-making process. Those are sort of nicely packaged because, having been to LUBA and back, we put them in reverse chronological order and have a list of the oversized exhibits. And now it also includes the materials that have come in during this 2017 process. So the record before you to be considered is the whole thing. It's been provided to you electronically. We have it here today if you want to pull anything from it. The 2017 record, as Eric explained, was assembled through a really prescriptive process that was described in the notice. The notice is attached to today's AIS. It's at pages 7 through 9 if you're interested in looking at what came in during the 3 periods. The question of whether anything needs to be rejected from it is kind of two-part. It basically is if there's anything that was submitted in violation of the notice. So either it came in late, so not during the right time period, or it came in and it addresses things that are outside of the scope that was identified. So there's 3 different things I want to talk to you about in terms of the content of the record and potential rejection issues. First, there's a formal motion to strike that was on page 210 of the record. It was filed by Paul Conti. And on that page, give you a minute to get there if you want. There are 3 memos identified by Mr. Conti that he alleges need to be rejected. An April 12th memo from planner Eric Berg Johansson, an April 12th memo from the fire marshal's office, and an April 10th memo from Public Works Engineering. Oh, you're good. Did you just pop that up?
Yeah.
Good.
Snap my finger.
So those 3 items there are the items that Mr. Conti says we need to eliminate from the record. His reason is that they were produced and submitted by city staff with the intent to bias planning commissioner's decision in favor of the applicant, and the content of these documents is therefore prejudicial and unreliable. So now I'm going to offer you some legal advice, and my recommendation is against you removing these 3 memos or rejecting these 3 memos from the record, because that is not a lawful basis for rejection. As I explained, if you believe that those are not reliable, you have the option of relying on contrary evidence in the record that you find to be more reliable. But in terms of a record before you, thinking that an item is unreliable or affected by somebody's bias isn't a basis for you to reject it. You need to consider it and then decide its weight. And that's true of any piece of evidence on the record. So my recommendation is that you not make a rejection based on this motion to strike. On the other hand, if one of you wishes to make a motion to strike any of these, now would be the time.
Does any commissioner feel the need to make such a motion? Or have more questions about this?
I have a question. Just, is there an expectation that staff is supposed to be unbiased in these quasi-judicial deliberations?
I think that it's helpful if staff, even if they have, even if they can look at something and say, I think I know how I would act on this, it's irrelevant to your decision-making process. So I think staff really tries to do that, generally speaking, but in some, this is actually, because this isn't in the record, I think this is something worth talking about at a later time. But, it varies from jurisdiction to jurisdiction, and it varies from era to era. At various times, our city staff have been very forward with recommendations. In this era, they're simply not. So that was the first item. Nobody made a motion. It sounds like nobody's moving that we reject any of those things. The second item regarding the record that I want to talk about is a letter that the city staff received. It's dated May 8th, which is after the record closed. So I have 3 copies here that you can share, but our recommendation is that you reject it because it came in late. It's a May 8th letter from Mr. Conti arguing for the rejection of some of the material in the final submittal from the applicant. And granted, it gets tricky because there's not an opportunity for someone to reject or to object to what comes in during that final submittal, which puts the onus on you. That's the third thing we're going to talk about, to really wade through that and make sure you don't think anything needs to come out. But because this came in late, if you want to accept it, it would amount to reopening the record and would require some more process from the body on this. And for that reason, staff recommends that you reject this letter. There are copies here if you want to look at it, but if you just want to reject it because it's late, that's satisfactory.
That's what I was going to say. I think it should be rejected if it's late, and therefore I don't want to see it. I don't
That's
want to
fine.
see it at all.
Any other commissioners have any questions or comments about this?
My feelings are the same as Commissioner Jaworski's.
Do you want a motion on this, Emily, or just,
Yeah, I think we do need a motion to formally reject
I
something.
move that we reject the letter.
discussion?
Dated May 8th.
That's helpful, thank you.
All right, all in favor of rejecting the letter that came in after the deadline, please raise their hands. Unanimous, 5 to nothing.
All right. So the third item that I want to talk with you about, and Eric can kind of help us work through it as well, is this issue of when we have when we give an applicant or anybody the final word, the record closes at some point. And that means the last thing that comes in doesn't have a public scrutiny that you can see as to whether or not everything that is part of that final submission is within the scope, within the substantive bookmark, or what do you call those? Bookends that we set out in the notice. So in this case, although the statutory 7 days for the applicant doesn't apply because this isn't an initial evidentiary hearing, it is the Planning Commission's practice to allow the applicant the last few days. And so the applicant was given an opportunity for final submittal, and it was to be argument only, and only argument that directly responds to testimony received during this 2017 process. So an opportunity to basically rebut through argument things that were brought up during the first and second open record periods. Our review of that letter, so the letter is at that final memo is at page 1 through 10 of the record, and it may be useful for you to actually pull that up and look at it. Do you have that up there?
Yeah.
Yep.
You're like magical. Our review, it seemed clear that it is argument only, that there's not new evidence in this letter that we identified. However, there are some areas that do appear to go beyond the scope of things that were raised during the first two periods. And so it's up to the Planning Commission to decide sort of what you want to do. That there are times when we reject particular paragraphs or parts of an item. And there are two in particular that we want to call to your attention. One of them I think is pretty clearly outside the scope. The other's a little questionable. So there's a paragraph on page 9 under conclusion. It begins in 2013 and it contains a quote from the hearings official decision at page 29. We all there?
Oh, yeah, there we go.
Oh, you can look at the screen
I got it on
too?
the screen, too.
Yeah.
I'm looking at it here, too.
There you go. So this particular entry from the term in 2013 and through the citation to page 29 of the hearings official decision, it addresses the city's TIA requirement at 9.8320 sub 5C, which calls in the TIA stuff at 9.8670. We couldn't find anywhere where anybody in the record in this part of the proceeding brought up this TIA requirement. And for that reason, I can't imagine that this would have any bearing on your decision, but in case it comes up, it would be better, I think, if this was simply rejected as outside the scope.
Commissioner Jaworski.
Yeah, I have a question. I get a little confused because he's limited in his rebuttal to what happened in these last two phases. Yet I believe I heard you say in the beginning that we're looking at the entire record as being open.
So it is tricky, and it's funny. I knew that it was going to be you and I having this discussion because we kind of put ourselves in an interesting situation here. It's totally legal, it's totally fine, but it doesn't quite fit in our usual code. And here's how and why that happened. So normally this body looks at the material that was submitted before the hearings official, and then looks at, based on that material that was before the hearings official, is the hearings official's decision the right decision? Do we need to just affirm it? Should we modify it, or should we reject it? So you're second guessing the hearings official based on the material that was in front of the hearings official. In this case, because the record was reopened, you have brought in new information the hearings official did not have, which means you can't simply ask, did the hearings official make the right decision? The hearings official didn't have all this information. What that means is, if I was in your seat, I would be looking at, okay, what did we decide in 2015? The hearings, or the Planning Commission had this record, 2015, we examined everything, here's what we decided. But now we have additional evidence. And the question really is, in light of this new evidence and argument that we've received, taking that in the context of everything else, does it change the weight? Does it change our mind? Do we want to decide a little differently now that we've seen this new stuff? So you're no longer really asking, did the hearings official err, or was there a problem with the hearings official's decision? You're really concentrating on this new stuff. And that is why, Commissioner Jaworski, we limited the scope of what could be brought in to just giving you a very closed universe of the new stuff, argument and evidence. So we didn't want, during this period of time, arguments and evidence about screening and landscaping and, all kinds of other things. That stuff is down the road. LUBA's, those things have all been litigated, and the issues at this point really are limited to a very few, and we wanted to keep that limitation for you in place.
That answer your question, Commissioner?
I guess so.
Kind of, if it
I
doesn't.
can understand the quote part because he didn't have that information when he's asserting the quote. But the other part that relates a TIA to traffic and its impacts gets into the three criteria. So I saw two different things.
Right, but at the stage when he submitted this, he wasn't allowed to bring up new issues. He was only allowed to respond to issues that were raised by others in the first and second period. And nobody raised issues with this one.
Okay.
So he's sort of responding to something that no one brought up, is the idea. Now, certainly staff is open in your review if you did find allegations regarding 83205C, or if you found something regarding TIA requirements, speak up now. Eric, you didn't find anything?
Nothing explicit, so I think that's why it's a little safer to just...
I think we all probably spent a little more time over the weekend looking at this stuff, but I didn't find anything more.
Commissioner Mills?
I just want to make sure I understand which text you're talking about dropping. It's,
Is it the bold?
It's actually everything starting in 2013 down to hearings official decision, page 29.
That entire,
Just what's on the screen, basically. Yep.
okay, thank you.
Yep.
All right.
Just a couple paragraphs, 3 paragraphs.
And I will point out that the reference to 9.6870 sub 1 in that paragraph is actually some numbers transposed, that in the actual quote, it's 9.8670, which is the TIA provision. So, and we didn't find references to that in any of the issues raised during the last two periods either.
Playing devil's advocate for a moment to your recommendation. I see here where he's saying he's trying to address what opponent's arguments were regarding safety risks, and he's attempting to refute some of the things that were said. That's what I'm understanding here. Mm-hmm. That seems to me to be fair game for him to do that in his final argument. So, you get where I'm going?
I do. It's questionable. And the next one I'll bring up, I think, is more questionable and probably not something you want to reject. This one, I think, is more, frankly, here's the way it works at LUBA. If you decide to let this in and then rely on it, and LUBA finds out, or LUBA decides that shouldn't have been in the record, you get remanded. If you let it in and don't rely on it, it's kind of a no harm, no foul thing. If you reject it, and someone says you shouldn't have rejected it, which probably would be the applicant at that point, then the applicant could say that was very, very important, and rejecting it changed the nature of the decision and remand. So, you just want to try to do what's most right.
Commissioner Nicolello?
Oh, no, Commissioner Mills.
Oh, I'm sorry.
Just a quick follow-up.
Yeah.
I'm sensitive to this because of where I was on the issue before. I want to make sure I'm not precluding arguments from the applicant that I should make sure I'm taking full weight in consideration. That's where I guess I'm trying to err on the side of making sure that I'm considering everything. And if we strike it,
Well,
I mean,
that is most of that is a quote from a hearing special decision, which is in the record anyway. So it's not like you have to, you're crossing it from this submittal, but a lot of that information is already in the record for you to rely on.
And if you articulate how this actually does relate to issues raised in the first and second, frankly, I think this could go either way. I would want you to make those statements so it's on the record, and then I think we could move on if no one wants to make a motion to reject it.
Commissioner Nicolello?
I'd like to make a motion to reject it. I think that at this point, the decisions of the Planning Commission, however well-intentioned, have prejudiced the rights of either party at this point. And so I think that considering the significant risk of including it, perhaps significant is too strong a word, but in considering the risk of including it, to be fair to both parties, I think that we should reject it in this instance. And including looking on attachment A of our AIS on page 8, we have a list of the criteria issues pertinent to the first record period, and it doesn't sound like either party objected to those. And I don't think that this relates to any of those criteria in this instant, as the TIA is not a requirement that applies to this application, as they were not required to do one. So I think in this instance, I'm okay with rejecting this portion of the evidence.
Is there a second for the motion?
I second.
Okay, any other discussion before we vote to take this out of consideration? Seeing none, all those in favor?
Do we need to firm up that motion?
Well,
It was a fairly clear motion.
I was going to say, I just want to make sure that I make that really specific.
I
so can
understand that you're
read
talking about all the text starting with the word in 2013 all the way through the text that says page 29.
Yes.
Okay, is everybody clear on that? All those in favor? 4, opposed? 1.
So the second area, the rest of this letter seemed to be really quite identifiably relating to things brought in the other two periods. On page 1 of this letter, arguably the third paragraph.
Yeah, sorry. I'm catching up here. Sorry.
You're good.
I'll just go like that. Okay.
Yeah, there you go. So it's this paragraph that references infill and the city's commitment to combating sprawl. I read this and kind of that struck me as maybe outside the record. On the other hand, I did note that there's material in the record that just kind of generally says, go to Junction City, go to Veneta, they're beckoning, go there, we don't want the infill kind of general testimony. So this might relate to that. I think this one's less clearly beyond the scope, but something I thought worthy of your consideration.
Commissioner Baker?
This particular paragraph popped out as being not relevant to this criteria that you set forth. And it wasn't mentioned earlier in that. Again, I'm indifferent about whether it needs to be removed, but I didn't think that this was related to the criteria that you mentioned that the comments were supposed to be related to.
Commissioner Nicolello?
I think that I look at this paragraph from, in addition to these amenities, the project will provide very real and very tangible benefits, down to the second sentence that talks about a public access way. That doesn't strike me so much as a substantial argument as it does an emotional argument. And I think that at this point, you know, and there might not be any legal differentiation in that, but it's not anything that relates to the substance of the evidence brought up in the record. And so I think that I would be comfortable striking that. I do think it's okay to keep the second part of that paragraph, as I believe that does relate to the criteria that is part of the, that is being considered as part of the appeal, but I defer to legal counsel on what they think is best in that regard.
Any other discussion?
So I just want to be clear, because I think we're talking about two different paragraphs.
Oh, I'm sorry.
And
Well, I'll tell you, that one struck me as funny
yeah,
too.
I mean, this is kind of introductory text.
Okay,
you know,
so just
but
to clarify.
it's this Oakley Meadow tentative PUD.
Yeah.
That's the paragraph that.
So I would add then that second part of the third paragraph as well, strike, or the fourth paragraph. But I think what I'm saying still stands for the first one as well. I mean, it's, my apologies, I didn't realize where the end of that was, but I think that that entire third paragraph, and then I would even go down to
The first sentence.
the first part of the fourth paragraph, but it's an argument that doesn't respond to the substantial evidence in the record. It's one that really is more emotionally tied to more of an emotional argument, and I think that in this case, it's really not pertinent to what's in the code at this moment. So I'm okay with striking that third paragraph, or rejecting it. I apologize.
Commissioner Mills?
I guess I'd kind of like to make sure we do one thing at a time here. We're talking about council's citation of the third paragraph, and Commissioner Nicolello is talking about the fourth paragraph. Can we do one at a time?
I adjusted to what I was saying to apply to the third.
Okay.
So just the third.
Yeah, just the third. I think that my argument still applies to the third one. But thank you for checking in on that, Commissioner Mills. It's a good reminder.
I'm going to put myself in the queue. For me, this one, if it stays in, I don't think it has substantial. If there was a reference back in the big thing about sprawl and those types of things, I think I'm fine with leaving it in. I don't think it's going to be brought into the deliberations. At least I won't bring it into the deliberations, and if we do, we could also come back and visit it at that
Absolutely. If it becomes pivotal, we'll want to maybe look closer.
point. Right.
If you
Any
don't.
other discussion on whether to leave it in or take it out?
Again, it just popped out to me, you know, I think it's irrelevant, this particular paragraph, so whether the determination about whether you're leaving in or out is another issue, but this paragraph just popped out when I read this testimony, that this was unrelated to the street width or length, you know, the...
Okay. Commissioner Mills?
I guess I'm in agreement with both of you. I'm kind of in the irrelevant camp here, but I'm also reluctant to start striking the applicant's document.
All right, if there's not a motion to remove it, we'll move on.
Okay, and I think it's fair to remember that you can, if you find, you know, at any point in time, if you find something that you think was submitted at the wrong time or outside the scope, we can talk about that.
Okay.
I'm
Commissioner.
fine with not making a motion. I think it's okay to wait, and I'm hearing that there's consensus around that, so.
Okay.
Thank you for your thoughtful consideration.
I just wanted to say to Commissioner Nicolello, I could go either way. So,
Yeah, exactly.
right?
Yeah.
So,
Just going with the way the groups seem to be feeling, it sounds like we'll be thoughtful about it if we reach that bridge.
Okay.
Okay, one final thing I wanted to talk to you about before I turn the wheel over is sort of how to think about these LUBA decisions that have already happened, because I know that it's probably quite tempting. LUBA has addressed all of the issues, or many of the issues, I should say, that have come, that are before you again. And it's tempting to just simply rely on what they have said. But I want to let you know kind of how I think LUBA's decisions weigh in the context of all the other evidence. So we can't simply rely on what LUBA has said about these issues. LUBA's decisions, I think, are important evidence in the record, and that you should look at what LUBA said, but you need to remember a couple things. LUBA's decision was remanded by the Court of Appeals based on a procedural error. So although LUBA walked through all the substance that was presented to them in that appeal, once it was remanded by the Court of Appeals for a procedural matter, that basically kind of vacated the substance of LUBA's decision. So it's interesting to see what they said, but it isn't binding on you, and it has no legal force. The other thing is it's tempting to assume that they would just decide the same way again, but we can't assume that because they, like you, did not have all of the stuff that's come in this 2017 process. So they will sort of be in the same spot as you will by looking at probably what they decided before and whether what they see now changes their mind on some of these issues that are the same. So it's part of the record. It should be considered, and I will try to dutifully remind you when you're talking about an area where LUBA has addressed it to kind of put that in the mix of things that you consider, but you can't just kind of rest on what LUBA said. You need to talk about how the new information might change your initial decision or what LUBA had to say about it. So with that, I think that deals with all of the process legal stuff that I wanted to talk about before you get started.
Okay.
Good.
Yeah, and if I can, you probably noticed in the AIS on page 5, we outlined the recommended order of, and you have the packets in front of you, but of issues to address. And so kind of the reason you'll see issue 3 is listed as the first. The first 3 issues are kind of the ones that there's a lot of evidence in this new record about, so we thought it would be more productive to start with those. Those are kind of the juicy ones that are going to probably require the most discussion, so that's really the only reason that those were put up front. And so what I've done here is I've just reordered, on this sheet that I have right here, I've reordered them, the appeal issues, in the order that we recommended, so I can pass this out if the commission decides to follow that order. That way you can go through it more easily and kind of see the sequence of it. Is that okay to do?
Yes, please pass that out. And after going through that, this kind of goes through a procedural issue that we've had before. Sometimes if you affirm or deny one of them, it kind of trickles down. So that's the same type of procedure that we're going to go forward with this.
Yeah, we should.
Okay. Anything else from you, Eric, at this point?
I don't think so.
Okay. So for me, I just want to say a couple of things. One to the people who are in the audience here, and to the people who may be watching on TV. And this is just for my personal thing. We're all just citizen members, volunteers that volunteer to do this. We're not lawyers. We're not, or at least I'm not a lawyer. I'm not a land use planner or anything like that. So we do our best to make the best decision that we can. And if it goes your way or goes opposite of your way, it's just what we feel is our best interest and what we have in the record. So I appreciate the rest of the commission for being able to go through these intense processes and do their best to make a reasoned decision. So with that, I think we can, after 45 minutes of procedure, we can actually start digging into the remand issues. And we're going to start with the number 3 one, which was the decision erred by finding that the applicant met EC 9.83206. The PUD will not be a significant risk to public health and safety, including but not limited to soil erosion, slope failure, stormwater and flood hazard, or an implement to emergency response. And then there's 2
Correct. Impediment.
Thank you. And then 2 sub-assignments. So I'm going to open it up to the commission and hear what you have to say. Commissioner Baker. Thank you for breaking the ice.
Having read the material in the record, I have some concerns about this related to the last category, which is impediment to emergency response. So I just wanted to flag that there was some information from our council as well about clarifying the definition of a quaying street related to pavement width. And also there was several new traffic engineering studies in the record that talked about the impact, the potential impact to emergency response of that particular street. This is a difficult issue because we have a cul-de-sac that's about 1,000 feet long, and our guidelines usually try to have cul-de-sacs have a maximum length of 400 feet long. So we already have there's already an issue that exists just in terms of length. And now we have this issue with narrow street with parking on both sides, which you saw from the photographs submitted. It looked to me that there could be an impediment to emergency response on that particular street. So I'll just leave it with there as an opening sort of comment on this particular element. I should mention also that when you read the record more clearly, some things come out that I have to admit that we missed the last time around. The whole idea of a quaying street is 14 feet plus 7 feet of paved parking was sort of somehow that didn't get into our discussions in the previous deliberations or in Luba's deliberation that seemed either at the time. But that seems to be relevant. In other words, 14 feet makes sense as a street with as long as you have this quaying space to pull vehicles out of the way when needed. And also there's the issue of this the fire hydrant, which apparently needs a certain specific amount of space to function with a fire truck and its location. So again, I have some concerns about this particular issue number 3 related to the impediment to emergency response. And I'd like to hear from other commissioners to see what they think.
Commissioner Nicolello.
Yeah, so this criteria is a tough one because it's a little bit discretionary in nature, at least in my opinion. And so I think that it's important to recognize that 29 units is an impact on the street. That being said, the criteria itself calls for the PUD will not be a significant risk. And so the question is, what does that measure of significant look like? And is that impact significant enough to merit that it would be, that we could consider it under this criteria? And I'll be frank, there was not enough units to generate a traffic impact analysis. The applicant did elect to do a traffic study and did suggest mitigation through required improvements, and then also, I believe, an irrevocable petition. So at one point, when the city does decide to bring that street up to proper standards, that applicant has already basically committed to participating in those. And so I think my question for staff is just also for the purpose of just kind of hearing it out loud. The formal agencies who will look at this when it goes to if it goes to building permit and things like that, fire, public works, and so on, have they verified that those improvements work within the city standards?
Yeah, I believe through the PUD evaluation, Public Works and Fire found that their standards were being met, at least for that development site, because I think what has been in the record a lot, and I know that the opponents may be saying different, but one take on it is that The only thing the PUD itself is required to improve is its own site and what's it's abutting, and not necessarily the entire street, but that is something that you will need to discuss as well. So I'm not saying that's the right answer. It's just, I think if you asked fire or public works, they would say the standards for that site are being met.
And they're also constructing their hammerhead turnaround for emergency vehicles and so on, which would
Right.
benefit beyond that. I think considering those things and also having considered the new evidence, including the Marion report, and then I believe there was an engineer who also wrote another analysis of that report as well. I think that I haven't found any new evidence that's compelling enough to change my perspective on the ability of the application to meet EC 9.8320 subsection 6. But I look forward to the rest of the conversation that the commission has to bring.
Mr. Mills.
Yeah, this, I guess, to me, this is the crux of where I was at and in my last deliberation on this. And the questions, a lot of the new information that came in was related to the right-of-way, both from the applicant and from staff and from supporters and opponents. Most specifically, though, I guess, as Commissioner Baker pointed out, the last time around we ended up focusing on going from 13.5 to 14 feet of paved right-of-way and making sure that happened, and the discussion of whether there was 21 feet of paved right-of-way, I think, became subordinated. And I'm just looking to staff for some guidance. Are we 21 feet or are we 20 feet is acceptable, required? Because we've got a lot of this right-of-way, a lot of the right-of-way that's in the plan is at 20 feet. The easternmost 250 feet is at 20 feet. So that'd be one question that I would have. Another question that I would have would be, I'm not sure, I did not lay out where these people's property is, but there were at least two letters that I read from people that were saying that they were not going to allow use of their property to enable transport on the street. And there are letters from Jim and Sharon Brandt and Lauren Reagan. And it seems to be a form letter that they used and said that they were not going to allow this. And I'd like to know from staff, what's the impact on the 20-foot or 14-foot passageway potential from those letters and those threatened revocal of access, if that's what the right word is. Once again, not a lawyer here. So that's a question I have. Is that an impact to what we're talking about? And I guess I'm also kind of dwelling with the same question that Commissioner Baker mentioned, that we've talked 20 feet, we've talked 14 feet, we've talked 21 feet. And I'm not sure that I also agree that the safety engineer has said it's good. I think, I'm going to withdraw right now and see if I can find in the record and quote back. But my sense was that there was a little bit of some qualification here in the comments made by staff. That's all for now.
Commissioner Jaworski.
Yeah, I had some difficulties with this, but the significant risk, as Commissioner Nicolello had indicated, is something that hits me, and that the developer, as we've seen in other developments elsewhere all through the city, they usually impact or if at all, build out in front of their site and improve in front of their site, or just pay SDCs and it's done at a later time. I also feel that although this is, let's say, ends in a cul-de-sac or is 1,000 feet long and we like 400, it's like a pre-existing condition. It's not the development's fault, the length of that particular street or road, the same as the conditions on it. I feel that if it had generated a TIA, which would be enough traffic, then there might be, for me to see, an issue to look at it and say, what is it really impacting that street? Because basically the minimal amount of new traffic that it'll generate, the existing safety conditions, whether it's built or not, if there are some there, are already there now, and I don't see why they become an issue that the developer has to address, because it's not creating a significant impact.
Got myself in the queue, and then Commissioner Baker. I'm glad that earlier on we decided to keep some of the things in the record that were proposed for striking, because one of them is the one that helps me get past this, and that's the fire marshal's report dated 4/12/17 on page 364. The fire marshal went back out there, looked at it again, and said the existing Oakley Lane in and of itself does not exhibit a significant risk to emergency response actions. And then further down, it says the proposed development accounts for actual safety improvements regarding emergency response, both for fire and related medical responses. So while there are portions in the records where engineers are looking at it and saying, yes, this is safe, no, this is not safe, this is the actual, in my opinion, these are the people that are going to be using this lane, and these are the people that went out and looked at it and said, yes, it meets the criteria, and yes, it actually helps improve the safety of Oakley Lane. So for me, I would affirm based on that as what I would affirm it, but I'm open to hearing other commissioners' arguments. Commissioner Baker.
Yeah, I think part of my concern is that there's apparently again, I'm just taking this from the record and my numbers may not be completely accurate here. There's 250 feet at the end with 7 dwellings on it. That's really the area of concern. It's where it's narrow. It's where emergency vehicle could very well feed it. And so, I just have some concern. We're adding 20, I can't remember, is it
29.
29 units? I couldn't remember if it's 28 or 29 units, which is a significant addition to the existing 7. So, one would expect, we have more households there. There will inevitably be some increase in the number of, could be a medical issue, could be a fire issue, fire starting at the end of the street, in the park, in dried grass. It could be, there, to me, it raises an issue of the city, the concerns where we're making a addition that has an impact on the ability for an emergency medical vehicle or emergency fire vehicle to get down that lane in the case of when there might be a need. And we are increasing the need for that event just by numbers. There's just no doubt that when we add 29 units to the 7 that are there, we're going to have a greater likelihood of an event happening there than there was before. So to me, that's a concern, and I really don't I know that there are a few other of these long lanes, and the city fire marshal, or I should say the Eugene Springfield fire marshal, has to deal with them all the time. Because we have a situation that's not ideal, or maybe even worse than ideal, it doesn't mean that we should extend it and make it worse. That's my point of view. So we already have a condition that's not, fortunately, there's never been an emergency response there that got blocked, but one could imagine that if an emergency response there got blocked and you can't get to the hospital within 4 minutes, it can have life or death, impacts. So I just feel uncomfortable given the status of this last section of pavement, where the problem is, where we have 7 houses, and now we're adding 29 more. And we're saying that somehow doesn't impact the potential for impediment to emergency response.
So, thank you. I think one of the things that we do need to consider here is if we are planning on overturning this, we need to have findings and specifics as to why we would overturn the hearings official and where the hearings official failed to say that this meets that EC 9.8320. So keep that in mind as we're moving on. I'm going to move on.
Let me make the correction. It's not the hearings official because, as our counsel has instructed us, we have new testimony now. So we're not.
No, you can use the testimony to make your argument, but what I'm saying is you still have to show that criteria is not being
Right,
met.
but it's not the hearings official determination. It's the criteria.
Yeah, exactly. Commissioner Mills.
Yeah, I guess I wanted to go back to what I had mentioned before. In the same fire marshal memo that was cited earlier, it's on page 366 of the record, I believe.
Can you give us a second to get there?
I'm getting there right now.
Oh, perfect.
Sorry.
Little horse race.
We also have it on the screen.
Yeah, here we go. And I'm looking at the, under applicable question, number 1, the existing Oakley Lane in and of itself does not exhibit significant risk to emergency response actions. A, currently there is a signal fire hydrant located approximately half the current length of Oakley Lane on the north side of this lane. This provides the required water supply for firefighting. No dispute there. Then he goes on, given that this lane is existing and has been in existence for decades, current fire code requirements for width could not be imposed for the lane itself as a standalone for fire department access. So to me, that's a significant qualification. He's saying to all the good stuff, other things he says here, that's a significant thing he's saying, and it bears with what Commissioner Baker has brought about that, yeah, there's an improvement that's being made, and I don't think anybody disputes this. The turnaround is being improved. This is a case where I'm not sure how you resolve the fact that the developer is offering to make improvements where they can, but a lot of the issues that we're talking about here are outside of the applicant's area. And I believe it will make it worse. And I don't think, we can talk about the word significant, which from my background, there's a statistical standard for significance, and I presume that's what's being applied here when we talk about whether it would trigger a TIA. But that was my and I'll save another point as we move along, but that was the point I wanted to bring up in terms of the qualification that is embedded in some of the staff recommendation.
Do you want me to answer the questions that you had during your first time around?
Thank you.
So I think you can correct me if I'm wrong, but you asked about the 14-foot of passage and how the road is affected by private property. Yes, and so that is an important piece here. This is the Eimstad survey that you've all probably looked at or remember it. So what it is basically telling us is that if you're relying on this, is that in a place where there's private property coming into the street, the Planning Commission identified an issue with that last time, and so a condition of approval was added to increase the paving width from 13.7 or something to 14. So that was one of the conditions of approval from last time, which still stands, right? So that gets to my next point, which is, okay, you're going to have 14 feet of paving. Then the next question is, do you meet the Queuing Street standard there? And the answer is no, because you need 21 feet of paving, right? So if you look at page, I just want all the commissioners to be clear on what the standards are, and then I can talk about really quickly like how those relate to the criteria. But on page 388 of the record, the opponents, it's in the record in various places, but the opponents added that local street standards table, and so those are our standards for new streets. So if somebody builds a new street in a subdivision, they have to meet these standards. The Queuing Street standard is the one, Alyssa, if you look on the board here, right here, a mouse, 21 feet of paving, which includes a 14-foot paved travel lane and a 7-foot paved parking area, okay? So that's just want to make clear that's the Queuing Street. And so could Does that 14 feet of paving here meet the standard for new streets? No. The right-of-way here, though, according to the survey, is 20 feet wide through that section where the private properties come up. Okay, so there's more right-of-way than there is going to be paving there. And what the commission found last time was but that doesn't matter. The 14 feet, we find that the 14 feet of paving is sufficient for emergency access. So that's what you found last time, but that's what you need to look at now and reevaluate that.
Follow up, Eric? So the fact that it's not 21 feet is not a deal breaker in the city's view.
Do you want to talk about what Luba said about that? Because I don't want to give my
So
personal...
Luba dealt with this particular criterion, subsection 6, in both 2014 and in 2016. The 2014 text appears to be less applicable to your conversation right now, but in 2016, at page 187 of your record, go there with me too.
Okay.
Sorry, it's taking me longer to get there than you. Let's see. Okay. So in 2000, I'll talk quickly about 2014 because that's not included in this part, but it's in the bigger record. In the 2014 decision, Luba agreed with the city. They say, we understand Conti to argue that the city improperly construed sub 6 because it failed to consider whether the configuration of Oakley Lane will be a significant risk to public health or safety, or be an impediment to emergency response. Meadows responds that Conti's argument misconstrues the plain language of sub 6 and impermissibly adds language to it. Luba says, Meadows points out that EC sub 6 requires the city to determine whether the PUD is an impediment to emergent response, not whether the configuration of Oakley Lane or all off-site streets would be an impediment. Meadows also points to the city's findings that the PUD will not be a significant risk to public safety or an impediment to emergency response, based on the future possible Hammerhead turnaround and the condition of approval requiring a temporary emergency access easement on the temporary emergency turnaround on the property until the permanent Hammerhead is developed. We agree with Meadows that the city properly understood the inquiry under EC 9.8320 sub 6 to be limited to a determination of whether the PUD is an impediment to emergency response, and there is no basis in the express language of the provision to support Conti's argument that the city was required to consider whether the configuration of Oakley Lane off-site will be an impediment. We also agree with Meadows that the city's findings are adequate to explain why the city concluded that the PUD is not a significant risk to the public health and safety or an impediment to the emergency response, based on the portion of Oakley Lane that is located on the subject property. So that was in 2014. More stuff came in. In 2016, on page 41, they begin, and they kind of come to their conclusions on 45 and 46.
Major record pages 191 and
Sorry, yeah, 191 and 192. Okay. Forgive me. Thank you. And here, this argument was largely about whether Oakley Lane off-site, so not adjacent to the development site, is required to comply with city standards. There's no question that this criterion requires safety. It can't be an impediment. The PUD can't be impede. But does it have to be exactly 21 feet? Does it have to comply with the 9.6 thousand standards? And Luba, at the top of page 191 in your record, agrees that Oakley Lane is not required to satisfy the 9.6870 right-of-way width standards.
Which page are you on now?
It's page 191 in your record. The argument about this criterion starts on page 187. But LUBA's conclusions are really kind of laid out on 191 and 192. The city and Meadows also respond that nothing in sub 6 requires Meadows to demonstrate that Oakley Lane meets the standards and the Eugene Fire Code, which is not an issue right now. Unless it is for you. I mean, it's been brought up, but LUBA determined the standards and the fire code are not approval criteria. And then on page 192, LUBA says the language from the design guidelines at Troutman sites is not mandatory and certainly does not unequivocally require the 21 feet of width. It sounds like you may be taking issue with that statement at this point. More importantly, Weischer did not testify that Oakley Lane meets the standards, but rather cited to the design guidelines as support for his position that the city allows narrow streets in other parts of the city. So LUBA decided that the evidence in the record is that a reasonable person would rely on to conclude that a 14-foot wide paved surface is not an impediment to emergency response. But that's just some more evidence in the record. This is not,
Right.
LUBA could change its mind based on what it's found too, but that's what they said then.
Commissioner Baker.
Yeah, I wanted to go up 2 paragraphs because this is the crux, the one that concerned me. And that's when it says, finally, this,
What line are you on?
line 12.
Page
191,
Yeah.
right?
Yeah.
Let me get to the
191.
line 12.
Yep.
Finally, the city and Meadows respond that the Planning Commission is supported by evidence in the record from Warshore that Oakley Lane at its current 14-foot paved width can safely accommodate emergency vehicles. And we have new information in the record that disputes that.
Right.
So we have a decision that's determined by testimony from Warshore that says this 14-foot paved width can safely accommodate emergency vehicles. Yet we have other information in the new record that shows shows 2 new traffic engineering reports that contradict that, and also photographs that show not only are there derelict cars parked on the lane that couldn't even be moved in case of an emergency without a tow truck, but we have firewood, we have vegetation. It's difficult for me to accept the initial testimony without also weighing in the newer testimony that contradicts that. And that's what this LUBA decision was based on. It was on this testimony by Washer that said, because they say down here that they're basing their decision on this 14-foot width is not an impediment to emergency response. But we have testimony completely to the opposite of that in the record.
Okay.
Based upon the conditions that exist on that 240-foot, 50-foot end of that street.
Okay. Looking at the time and looking at where we are in process, and we're on the first assignment of error, I don't want to limit discussion or anything like that, but I think at this point it would be poignant if somebody wants to amend the findings that they come up with some wording to do so, rather than just talk in generalities, is what I was hoping for. So I have Commissioner Nicolello first.
So I just have a question for legal counsel. I think that LUBA actually has a series of head notes on how to handle conflicting evidence. And it does happen. I mean, there are instances in which there is conflicting evidence in the record. So I'll say a comment and then I'll direct my question to you. I think the perspective that I'm approaching this, having looked at all of the evidence from all of the traffic engineers involved, I think that my perspective comes back to if the fire department says it's okay, and there's also a response from the original traffic engineer and Public Works has weighed in, I think that I would be helpful for me to hear from other folks, what other evidence compels them otherwise. And I think for me, it would have to be evidence coming from either, I apologize if I butcher the names, but the Namarian report or the other traffic engineer who responded. I don't think that it can come from anybody else who's not an expert in this case, because it is trying to contradict expert testimony. So it would have to be drawn, I think, for me personally, from those other reports that were submitted into the record. And then I will defer and ask legal counsel if they could discuss a little bit about what Luba said before in the past about what planning commissions can do when they do have conflicting evidence, and which one kind of how do we weigh those against one another?
Well, I'm not going to be too terribly helpful, because what Luba generally says is if both of them are credible and equally credible to you, what Luba will do is look at what you end up deciding and determining whether or not a reasonable person would have relied on that evidence. So, I think you have a difficult decision in this case. I don't think, it's all that clear. I will, for your assistance in talking about this, point out that the Namarian report is at record 426 to 440, and the Sabarian report is at record 243 to 247. You also got additional report from the applicant's engineer, Weischer, and attached to their final submittal at 106.
All right, Commissioner Jaworski.
Thank you.
Mine was somewhat along the lines that Commissioner Nicolello said, when Commissioner Baker indicated conflicting testimony, I wish he would have been specific where he's using conflicting rather than just saying that testimony. I just wanted to, so I could focus in on the lines he's looking at that he feels are specifically conflicting.
Commissioner Mills.
Yeah, I'm just going to, with all due respect to Commissioner Nicolello, I'm going to disagree, having served as an expert witness on an occasion. I'm going to give credibility to other items that I see in the record that basically provide accounts of conditions as they exist at a point in time, remembering that they are conditions as they exist at a point in time, but those are valid observations. So I'm not going to disallow testimony because it's not from an expert.
Okay. So at this point, I'm wondering if there is a commissioner who would like to make a recommendation on Appeal Issue 3, whether to affirm it or amend it or affirm it with conditions. And just for my sake, some of the conditions could be remove parking from part of the thing.
Well,
it seems to me, I don't know if that's allowable.
is mentioned in the record, and I did want to talk about it.
Yeah. So I have Commissioner Nicolello, and then.
So I think that before we get into anything like conditions, it might be helpful to ask staff what the extent of those conditions can be, because I wouldn't want us to move forward recommending a removal of parking and that be outside of the scope. There's some things that we are discussing that I think are larger public works issues that perhaps are more of a general problem that extend beyond the frontage of this development and its impact. So that, just a real quick staff check-in on that.
Well, I can give you the legal parameters, and then Eric can talk to you more about the logistics and what's possible. But
thank you.
Conditions are appropriate only when you have a criterion that can't otherwise be met, and you can craft a criterion that makes the criterion met. So I might have said criterion twice. Craft a condition that will make the application meet the criterion. You have to look at a condition and make sure that it's something that could feasibly be accomplished. Now, LUBA is very general with what is feasible. there's not much that Luba thinks isn't feasible. So if I think you're getting into an area where, you know, if you're trying to make pigs fly, I will stop you. But generally, Luba has said even if a condition would require somebody to obtain private property from another individual, that's feasible. So feasibility is an issue, and it's somewhere short of impossible. Also, you can't impose a condition that would basically push decision-making up. If the condition imposes the obligation on someone else later to basically decide whether it's approved or denied. So you can say what has to be done, but you can't say if the DEQ says blah, 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 blah. You can't basically move the decision to some other desk. And to determine whether a condition is met, the individual who has to decide whether the condition's been met later won't be having a quasi-judicial land use process, and for that reason, your conditions should be written in a way that's clear and objective and non-discretionary. So it'll be clear to someone later whether they can say yes, met, or not met. That's pretty much all I have to say about conditions.
Do you have additional thoughts on that, Eric?
Yeah, I might just read like two really short pieces from our staff memo, just so because I want to be careful about saying something that's new evidence, because I want to be careful with that. But so in our staff memo on page 145 of the record, we said the Numerium traffic assessment discusses the presence of vehicles parked on both sides of Oakley Lane. A photo included as Exhibit E1 shows, and I'm paraphrasing a little bit here, that cars are parked on both sides of Oakley Lane. If the commission finds that the lack of parking restrictions creates a safety problem in light of this criterion that we're talking about, then the planning commission could consider imposing a condition that would require the applicant to mitigate.
145.
Yeah.
145.
145.
Yeah, 145. The planning commission could consider imposing a condition that would require the applicant to mitigate parking impacts. And then we go on to also explain a little bit about what I think maybe Commissioner Baker brought up, which is about there being firewood and potentially some vegetation in the right-of-way. And our response to that is Eugene Code Chapter 4, Section 4.8552 states, wood for fuel may be left in a street or alley for not more than 36 hours if it does not obstruct the flow of vehicular or pedestrian traffic. And so those are codes that would apply to the portion of Oakley Lane. This is important. The portion of Oakley Lane that's within the city of Eugene jurisdiction, which is the majority of what's talked about in the last 250 feet. That it's in the traffic assessment by Numerium. That's that portion. And if you want me to point out on the map exactly where the city's portion ends, so Oakley property is down here. Okay. Here. There's
Eric, is this derived, is this in the record?
Yes.
Okay.
This was submitted, actually this version was submitted by Sandy Toms in the current proceeding.
Yes.
Okay, so there's 3 properties here that you know about that their property lines go into the current paving. And that's what those letters that you mentioned talk about. Okay. There's a flag lot right here. The city's jurisdiction ends right here. It's this to the right of this part. Okay. So, and if you look at there's no scale on there's that Numerium study that shows there's obstructions in the right of way. I think you're referring to their field notes section. We could bring that up if you want, but I just wanted to, it relates to the parking because parking and other obstructions are in the right of way, but I just wanted to make it clear that if there's vegetation or wood fuel in the right of way, we said in our memo here, based on the code sections above, regarding the wood and the vegetation and wood storage within City of Eugene right-of-way may be in violation of the Eugene Code and subject to code enforcement. If so, those conditions should not be a factor in the Planning Commission's review. I just wanted to clarify that, but more importantly, I just wanted to read that part from our memo about that we did bring up parking restrictions before, and that's something that you can certainly discuss.
Again, so I'm going to get back to, we need to keep this moving. So at this point, I'd like to have some sort of clarity on where we're going on issue number 3. Because we can sit around and talk about this all day. So if Commissioner Mills.
I guess where I'm going on issue number 3 is the the concept of the access way and the blockage, or the concern that it is being blocked, in the discussion of parking. And the same memo that we were discussing goes on to say on page 145 of the record, under parking restrictions, the Planning Commission finds that the lack of parking restrictions created a safety problem in light of 9.83206, then the Planning Commission can consider imposing a condition that would require the applicant to mitigate parking impacts. Now, I'm not sure I understand how we could impose that requirement on the applicant. I'd be open to hearing how that's possible. But I do wonder what kinds of other things the city could do on this access way. That was one thing in terms of parking restrictions and parking enforcement. And then also I'm wondering, Eric, did I understand you to mention that some of the property owners in this area we're talking about, that have property lines into the pavement, are saying they're going to restrict access?
I believe their letters that they submitted during this said they will not support people trespassing on their property.
Okay.
So,
For clarification, there is still 20 feet of right-of-way in front of those properties? It's just that according to that survey, it's just that
Not on
the
the
paving, right, the paving is not all within that 20 feet,
Right.
just so everybody's clear.
Did you want to answer the question about parking, what we can impose on the county
Well, this
parking
part
requirements?
is
This
in the
part's the
city.
city.
Right. Okay. Okay.
I guess I would just right now limit my question to, can we impose something in that part of the roadway that is city-owned?
Okay, Commissioner Nicolallo, and then Jaworski.
I think I'll make a motion for purposes of just getting a motion out there.
Yeah.
And then we can modify it as
Thank you.
need be, depending on where conversation goes. So at this time, I'll say I'm personally uncomfortable with requiring parking restrictions beyond the frontage of the property, because I think that that's an unfair burden to impose on the applicant. That's a
If you could make the motion first and then speak to
I
it,
just
that would be.
wanted to talk and give you
I
a
know,
preamble.
I'm trying to get it.
So I will say the decision did not err by finding the application met EC 9.8320 subsection 6. The PUD will not be a significant risk to public health and safety, including but not limited to soil erosion, slope failure, stormwater, and flood hazard, or an impediment to emergency response.
Is there a second? Seconded by Commissioner Jaworski. Now we have discussion on this motion. Seeing none, I will ask for the vote. All in favor of the motion, raise your hand.
I was going to raise my hand. Discussion.
Wait, okay. Commissioner,
I was wondering if you could bring up the photograph that shows the area of the instructions.
do you know what page that's on to help out or no?
yeah, I have it here. It is on page 281. I think that's the one you might be referring to.
I think he said one, Alyssa.
I know, but we have 2 pages in
Oh.
front of everything, so you have to add 2.
Okay.
So,
Oh, yeah.
could you identify where we're talking about the city?
Well, that's what I was saying. There's not a scale on this, so I can't speculate as to exactly where that line is on
You
this
tell me
map.
what flag lot is.
Do the boxes giving me, where the loading lots are? And
Well, there. I think this is. It's hard to read with this screen. Is that the fire hydrant?
Yep.
Okay.
Yellow is the, oh, I should take it back. It's
So-
colors, so that,
If you want me to bring this over. There's a fire hydrant on the survey. Okay.
okay, that's this here, is that correct?
And then the city right away is approximately here. Okay. Does that make sense?
Yeah, I just wanted to see it visually, I don't need this,
Okay.
before so I knew what I was doing. I wanted to make a remark that unfortunately enforcement for nuisance things is by request only. In other words, the city...
I want to be careful because I don't know that there's anything in the record about this.
Okay, all right, well, then I won't.
It's outside of the scope of our process, I think. I'm comfortable moving forward to a vote at this time.
Any other discussion? All in favor of the motion as presented? 3 opposed? 2, okay. And I think we'll be able to get it back into this on our next one. The next one we're looking at is the item number 11, which was a new one since our last discussion in 2015, if I'm not mistaken, and that is that the hearings official erred by failing to correctly assess the lack of adequate fire emergency services available to the PUD site as required under EC 98320 subsection 7.
Is the criteria actually written somewhere in the record?
Open for, yes.
I'm sorry, is that an appropriate code citation? EC 9.83207?
Yeah, it's a tentative, it's one of the tentative PUD approval criteria.
I have the,
Okay.
Confusion for me too, because some of the numbers are
Oh,
wrong.
interesting. Well, that one's correct.
Okay.
8320, and this is
There's an
the,
11B that's cited that we're supposed to look at, and there is no 11.
It's because this application was submitted under, older code.
oh,
For
right.
people
Could
like
you
me
bring
who are
up that-
Easily confused, you did confuse me.
Eric, if you could bring
Yeah.
that code if that code section is in there that we could put up on the screen, that might be helpful.
You're looking
yeah, is it
No.
this?
Oh, no. Don't even worry about
Yes, it is it.
Okay, so page 404 of your record,
Okay.
Mr. Conti has that section in there.
I'll continue what I'm saying in a second, but let's all take some time just to travel over there.
There it is, at the bottom of page 404.
Just give me one more minute. I'm a little bit slower on this thing.
So I will point out that this is a criterion that you didn't address last time. This wasn't one of them that was raised in the appeal statement. But because the record got reopened, the process that kicks in is that new issues could be raised. And LUBA found that this was an issue that was legitimately raised at LUBA, and so it was legitimate for him to raise it during this process. So you won't find as much of your previous analysis on this one.
And you said it was 404.
404 to 405 is where it's raised by Mr. Conti.
The very bottom of his.
Okay.
He also addresses it on page 81 to 82.
And then,
I'm sorry, I didn't mean to.
just
Sorry.
to clarify why this is being raised, Mr. Conti says on page 405, he says, the question commissioners must answer is simple. Would adequate fire service be available to the 29 dwelling units on the proposed PUD via Oakley Lane? And then he goes on to discuss that more, but that's the question he's raised, regarding this criterion.
So I will follow up and say, so subsection 7 of the tentative PUD criteria, I think it's important to read because it's a little bit different than subsection 6, but adequate public facilities and services are available to the site, or if public services and facilities are not presently available, the applicant demonstrates that the services and facilities will be available prior to need. Demonstration of future availability requires evidence of at least one of the following: prior written commitment of public funds by appropriate public agencies, prior acceptance of the appropriate public agency of a written commitment by the applicant or another party to provide private services and facilities, or C, a written commitment by the applicant or another party to provide for offsetting all added public costs or early commitment of public funds made necessary by development submitted on a form acceptable to the city manager. So in this case, we have seen that the fire department has accepted their proposed mitigation requirements. Would they be doing this through a PEPI? Would it be a privately engineered public?
Not in the record.
Not in the record. Never mind, strike that.
I don't think.
Nope, better safe than sorry. forget I said it. In this case, then, I will just rest on the arguments that we made in the previous conversation relating to subsection 6, that there is an acceptance by the fire department that the proposed mitigations are appropriate and that they will be adequate to serve the site and to serve the PUD.
Mr.
And thank
Mills.
you for catching me on that.
For the record, that's not the way I read what the EFD has said. I read it to say that it is improved, but that the modern standard or the new standard is not required because the lane is in existence. That's the way I read it.
Mr. Baker.
Yeah, I don't understand Commissioner Nicolello's comment. I see these three criteria. A written commitment of public funds. I don't see that's done. B, a prior acceptance by the public publication C of a written commitment by the applicant or others to provide private services and facilities. Again, I don't see where that was done. The third one is a written commitment by the applicant and other party to provide offsetting all additional public costs or roads. I see in none of these three cases do I see where the testimony in the record from either the fire marshal or the public works answers those three criteria. So that, to me, is a quandary.
May I respond to Commissioner Baker? I think it's important to look at the last sentence of subsection 7, not in the ABC, but it says demonstration of future availability requires evidence of at least one of the following. So you can choose any of those options. I'll also say, too, in this case, the applicant has proposed measures to mitigate that the fire department has said are acceptable. I also think it's important to emphasize as well that any new development, whether it's a new single-family home to what we propose now, will have an impact. The question, once again, though, is that will they be able to provide the necessary services and facilities to provide for appropriate and adequate operation of the PUD available prior to need? And I think that the impacts that have been the measures that have been proposed to mitigate we've seen them be accepted by both Public Works and the fire department. So once again, if anyone feels otherwise, very similar to our previous conversation, I'm going to need to see specific pointing to a page in the record or more that would direct us otherwise.
Mr. Mills.
I guess I would just direct us back to the fire marshal's statements that he made, and I'm just taking those as they stand. And to me, they do not provide, an endorsement. They do say it's an improvement, and I think the improvement that he's citing, once again, I'm having to infer, is the addition of the turnaround space at the end of the road. And we also know that the applicant is putting fire sprinklers into the structures to try to alleviate the potential for a blockage of emergency access, although that doesn't address EMT access.
And I'm going to put myself in the queue here. I think there is a subtle difference between the last one, between number 3, and using the fire department's, the fire marshal's recommendation, because the fire marshal in that one does specifically say that the PUD does not exhibit significant risk to emergency vehicles. That's not exactly what's being asked in number 11. So I think there is some subtleties to that, and relying solely on the fire marshal's newest letter, I can see where that would tend to give some people some pause. But I do believe that from what I've read in the record, and I can't cite exactly where and when, but my overall take from the record, I believe that that there is adequate fire and emergency services available to the PUD. So with that, I'll make a motion that the hearings official did not err by failing to correctly assess the lack of adequate fire and emergency services available to the PUD site as required under EC 98320/7. And as far as findings go, go ahead, Eric.
I just wanted to point you to a couple things, back to Commissioner
Wait,
Nicolello.
is there a second on the motion?
Yeah, let's,
Okay, sorry. My bad.
Yeah.
Okay.
Sorry, okay.
Thank
That's
you.
a good process
My
check.
fault.
Okay. Just real quick, Commissioner Nicolello had asked about whether or not there had been, what kind of permitting perhaps there had been for the improvements. I wanted to point you to attachment C of your AIS, is the hearings official's decision. And these are some conditions that the hearings official imposed and were left. And there's kind of three things that are related to this particular topic that's in front of you right now, and that includes.
What page are we on?
So it's page 97 of the agenda item summary.
Thank you.
And I just wanted to point out, actually, conditions 5, 6, and 7 as they relate to this, the dedication of the temporary emergency vehicle access easement over the on-site hammerhead and access drive from Oakley Lane. They also had to provide documentation from eWeb, and then the irrevocable petition for the public improvements in Oakley. Just wanted to bring your attention to those.
And I think it's important to just go back to the issue that we outlined it on your green sheet that I gave you today, which is the hearings official erred by failing to correctly assess the lack of adequate fire and emergency services available to the proposed PUD site as required by 9.83207. So that's the issue that you need to look at. So, but thanks, Alyssa, for clarifying that.
Okay, now we have discussion on the motion. Commissioner Baker, anything before I close discussion? All in favor of the motion, raise your hand. 3. Opposed? 2. Okay. Flipping back pages. The next one we want to look at is the number 4. The decision erred by finding the applicant met EC 9.832011/B. The PUD complies with all of the following. EC 9.6505 improvement specifications 3/B streets and alleys, 4 sidewalks, 5 bicycle paths, and accessory.
Commissioner Brodsky,
Yeah.
I'm sorry, do we need to do issue 2?
I'm sorry. Yeah, let's do 2.
You mean to say it after you read all of that?
Yeah, after all.
You did great.
I'm gonna submit to issue number 2 as is presented in the AIS, rather than read all of these.
So I wanted to ask, in my review, I'm not telling you this is fact, but my review indicated that it was just 2A that became an issue during this last proceeding.
There may have been some testimony, and I can look back, about pedestrian bicycle, whether or not that was
There
safe.
So let's talk about A and B. I think C was the TIA piece that I really kind of looked for and didn't find, so probably not as much discussion needed on that one.
Okay.
Thank you.
And I will look for discussion from staff when you're, or from commission when you're ready. Commissioner Baker.
I just have a question for staff. So was the plan that a sidewalk would be provided by the applicant along their section of the street?
The irrevocable petition would, if it was built, it would have a sidewalk in the future.
I just wanted to clarify that.
What?
as well.
when it's built.
Yeah. When it's, yeah.
And I'm going to put myself in the queue. As I recall, the last deliberations on this, this had to do with the actual property, the actual PUD. Is it safe and adequate within the actual PUD as I recall? Is that correct, Commissioner Mills?
Yeah, I think this gets into, whether we're just going to talk about what the PUD can do within the confines of its property line, or whether the reading includes, circulation to nearby points of interest that cyclists and pedestrians would have. And in my last go-around on this, I landed on it has to include circulation to the nearest points of interest and safety there. And once again, this gets back to this conundrum that we're facing, where PUD is not expected to make improvements all along the street. Yet, is it safe all along the street? And last time I voted, it was not. So this is a real tough one to come to a decision on.
I'd be happy to let you know what Luba said about this, if that's useful. This is one you addressed both times. Okay. I'm going to skip kind of through, starting on page 169 of your record, which is page 23 of Luba's 2016 decision. It's the first assignment of error raised by Mr. Conti, and they say, I'm going to read portions right from their decision. The issue presented in Conti's first assignment of error is whether EC 9.83205A requires Oakley Lane between River Road and the subject property to meet the standards in 9.6800 through 9.6875, which specify standards for streets to be dedicated to the public as a condition of development approval. Next page, skipping a quote. In his decision, the hearings officer interpreted this standard as not requiring an existing street to meet the standards in 9.6870 in order for the PUD to be approved. And a bunch of footnotes. In its initial decision, the Planning Commission agreed with the hearings officer's interpretation of 5A as not requiring existing streets to meet the standards in 9.6870 and adopted the hearings officer's findings. On remand, the Planning Commission adopted the same findings. And then finally, on record page 173 in their conclusion, Luba says EC 9.83205A, when read in context with the provisions referenced in it, particularly 9.6805 and 6870, ensures that streets, alleys, and other public rights-of-way to be dedicated by the applicant, in quotes, as a condition of development will meet minimum city standards prior to acceptance of them by the city. It does not require the entirety of Oakley Lane to meet the standards in 9.6870 in order for the PUD to be approved. In the context of this discussion, they also point out that sub B is a different standard which uses the term nearby, and they felt that that did not come into play under sub A.
Commissioner Nicolalo.
I think what's important for sub B in this case is the part of the criteria that says, it's about midway through it, provided the city makes findings to demonstrate consistency with constitutional requirements. And I think in this case, we need to be really careful how we discuss this issue, because we wouldn't also want to imply, we wouldn't want to force any conditions that would violate Nolan Dolan and have any, we want to make sure that we have rough proportionality. And so in this case, I think the way that I'm looking at this, and this is kind of similar to what we've discussed before, is they are making improvements along the frontage of their property that is roughly proportional to their direct impact. They are making on-site improvements necessary to serve the residents of the future PUD. And they are also making the other necessary improvements, such as hammerhead turnaround and things like that, plus the irrevocable petition. And the irrevocable petition signifies that when the street does get improved to future standards, that applicant has already been conditioned that they will have to go along with that new street improvement. So I think that all of those things considered, I haven't seen anything in the record that would change the way that I've looked at 2A and 2B, and then also for the purposes of the audience even though 2C wasn't really throughout the record, I don't think the TIA criteria would apply in the first place because they were not required to do one. They elected to submit a traffic study. So I'm sure we're probably going to want more discussion, but that's where I stand.
Mr. Baker.
The one area that I had some questions was A, because we had another traffic engineer suggesting that it should be a different turnaround than what's being proposed in the record, and whether that would be something that would fall under that category of 4A. And I can go and cite the actual testimony by Marion if you want to tell me what page it's on. I could bring it up so that it's clear.
You don't have the page?
So it's hard for me to jump around.
Record 426 to 440.
So it's
You said it was about the turnaround? Okay.
turnaround. So I think it's
Okay.
While we're looking, can I go to
Yeah.
Commissioner Mills?
yeah.
Yes.
This is a question for staff, and I'm looking at 96505B. And I just ask the belabored question in terms of the developer shall pave streets and alleys adjacent to. What is the normal, typical term or definition, meaning of adjacent in this context?
What was the...
No,
Sorry, Miss.
go ahead.
No, go
It's
ahead.
not a legal question, it's an interpretive one.
Yeah.
It's clearly something different than nearby, because they say adjacent and nearby in B. And I'm trying to, where, are you, did you say sub 5B?
Yeah.
This. So the Planning Commission, you did look at this. It's on page 15 of your AIS. So the packet that we
Oh,
gave.
Okay, wait a
6505.
second.
0505.
So, but
I'd say that number were
if we're, did you find Commissioner Baker's
Put it past.
They both have the word adjacent in it.
before? And I'm sorry for this, Commissioner Mills. We jumped ahead while we were looking.
Sure.
Yes.
And I don't want to
problem.
jump again ahead if he's found the correct page.
Well, it's page 436, and it's under the section where just got it. It's on page 435, actually. And it's the section here where it says, cul-de-sacs for emergency vehicles. Response, Oakley Lane is an approximately 1,000-foot dead-end street with no emergency turning radius at its eastern terminus. However, the city's final order requires a temporary hammerhead turnaround on the PUD site.
Okay. And you,
Well, elsewhere in the report, this engineer talks about that there are two styles of this turning radius. There's a partial or whatever. It's just whether that would be a better serve than this hammerhead turnout. That's the normal procedure. And, again, how would this be upgraded later on once it's done? Is there anything in the record that requires it to be replaced by the proper turnaround at some other point in time, or is this forever?
Well, when, if a building permit is reviewed, the Eugene Springfield Fire Staff will re-review it and confirm that it meets their standards. And I believe, and I even though something's locked into the PUD, I believe the fire can require something a little different through their building permit review. Like, it might not match to the exact foot. Does that make sense? Between what's shown on the approved PUD and what's approved through a building permit. I mean, they're going to be reviewing that again, and it absolutely has to meet their standard. The turnaround absolutely has to meet their standard through a building permit. I think that's pretty clear in the record.
Now we're back to Commissioner Mills's.
What do you think adjacent to means?
At the first blush, one would assume that it's properties, roadways that are contiguous to the property. But adjacent means, could that, obviously Mr. Conte has extended that out a quarter of a mile. I'm not trying to do that. I'm just trying to find out if there's a norm. I don't have a preconceived idea, Counselor. I just looking for guidance here.
Answer. Yeah, no, I mean, it's one of those lovely moments when you guys get to interpret the code. I think it's very well accepted that adjacent is another word for abutting, which would generally mean it's touching. Whether or not that is how it's intended here may be more of a question for you guys to answer. I don't think it's oh, you do have a land use code. Is it defined?
No, I checked.
Okay,
Sorry.
so there you go. I will point out that in a number of places, the code uses adjacent to or nearby, which would imply that they're not the same thing. In fact, the one I was accidentally looking at uses the phrase, which is subsection 5B, which is the criterion we're under right now, so
Yes.
it's ironic. But it uses the term as well as to adjacent and nearby residential areas, which implies they're two different things, if that's helpful.
Is nearby farther away than adjacent? I presume it would be.
Nearby would be further away from than adjacent.
Yes.
I think that's supportable.
Okay.
I'm adjacent to Eric, nearby.
I'm nearby.
Yeah,
Adjacent.
yeah.
Okay.
And isn't this,
Excuse me, just a moment here. First thing, what I would like to do is address what Commissioner Nicolello said about the code, and it's her interpretation that it's not in the code, because we've had that before where a commissioner has stated for a statement of fact that may or may not be there, and I don't expect Commissioner Nicolello to know every word of that code.
I hope not.
So in a quick review, you didn't come up with a definition in 0050.
Yes.
Thank you.
Here,
So
I
that,
can-
I'm just careful of that because of what happened at our last proceedings, and I don't want that
Yeah.
going forward.
I can specify, in a quick review of the code, the phrase adjacent is not in the definitions contained under EC 9.0500 in my review, which may
That's
or may
fine.
not be correct.
That's fine. Okay. Now, again, I'm looking here at our time. We're scheduled to adjourn in 3 minutes. So I'm just wondering what the recommendation of the commission is here as far as this issue and the other 9 that we have to go through. Commissioner Baker.
Yeah, again, if you go to page 431, number 2, we're talking about cul-de-sacs. This is from the ODOT standards. Cul-de-sac will normally terminate in a standard bulb. If the standard bulb is not feasible, then a Y or T turnaround will be used. And it goes on to state that Oakley does not have a cul-de-sac bulb or a Y or a T turnaround. However, the city's final order requires a temporary, whatever that means, temporary hammerhead turnaround on the PUD site. I'm just curious if this is the application that we would set that the bulb would be created for this long cul-de-sac. Why wouldn't we would be requiring a Y or a T, or, in this case, a complete bulb?
Commissioner Jaworski. Okay, you're ready.
Yeah, I'm sort of confused, and I guess to address this issue, it's been brought up on several different pages. The temporary turnaround is just until the permits are issued so that the cul-de-sac is built? When is the time frame there? That's, I guess, the question. That's what I'm seeing in this question. I'm sure Commissioner Baker has more to it, but I'm just seeing the issue of how long is the interim before we have let's say the hammerhead, whatever it is, built. And I also want to state that I have no problem with what that actual size is, because I'm sure in the final end that they'll make some minor changes, but if the fire department said that they can turn around in it, I think probably almost everybody else could too. So I'm not worried about that. But I mean, I do have a question. How long can it be an interim turnaround before the other is built?
So
Is that anywhere mentioned?
I'm going to direct you back to the hearings official's original decision. Page 19 and 20 talk about, under this criteria, talk about the hammerhead. And it talks about, now I just lost the piece of it.
Is this attachment to the AIS or?
It's on the AIS. It's page 53. So the applicant has identified, I'm paraphrasing here, but identifies the amount of right-of-way necessary to construct an emergency vehicle turnaround at the end of Oakley Lane and to provide the necessary frontage for flagged lot development of undeveloped adjacent lands. And then it goes on to say, well, let me jump forward. Then there's a condition of approval that was imposed by the hearings official and affirmed by you all that they provide a temporary turnaround. So the temporary emergency vehicle access easement over an on-site hammerhead and access drive from Oakley Lane and showed on the final plans. And then again at the top of page 54, it says construction. Oh, this gets a little confusing. It says construction of the hammerhead is not necessary or feasible at this time. The need will be based on further development of adjacent lands to the north. The right-of-way secured with this development will enable future development or the northerly property. So the hammerhead refers to the future kind of what would be, the bulb or the cul-de-sac. That would be the end of the cul-de-sac. At this point, that's not being developed. They are providing an emergency turnaround on their property until those properties to the north are developed.
So when the fire marshal said that the turnaround is adequate, he was referring to the interim turnaround?
Yes.
I don't know. It appears so. Yes.
Commissioner Nicolello, and then
That's what I was going to actually address. Do we want to wrap up this last issue item and try and do so in probably an efficient amount of time? And then I think these would out of fairness, probably need to be addressed in next week's deliberations.
Okay, so we are past time. First, I'd like to have a motion to extend till 1:35.
Okay.
So moved.
Okay, with that, all in favor? Okay. With that being said, I want to ask a straw poll of the commission. Do you feel that you have enough information on this that we could make a vote on this today, or would you like to keep the discussion going until our next deliberation?
And just to be clear, you mean assignment of error number 2, not the whole thing?
Right.
Thank you.
Yes. Straw poll. Do you guys think we can make a motion and vote on this in the next 3 to 5 minutes, or do you want to continue, just table this, close the meeting, and continue at our next meeting?
I think I have enough for 2A and B.
I do as well.
Anybody else on the commission? I see 2.
I'm pretty soft on it. I'm not where my fellow commissioners are.
And Commissioner Baker?
I think if we need to have a little more discussion, then I think it makes more sense to try to.
Okay, so I will concur with the latter two. I think that if the commission feels that there's more discussions that's needed, I will say we'll push this off to the next meeting before we make a thing on that. What I would hope is that going forward, when we have, if you are coming to these and you think you have substantial reasons to say that there was an error, kind of have that formulated out so that we can not just generalize it, because we are on a tight time crunch here. We have to finish this up. It has to be done by June 8th, is that correct? we only have one more meeting scheduled for this, so actually we're going to have one more meeting and probably a portion of a third one to go over the findings and the final order. So on the next meeting, we need to be sharp and tight. If you've got issues that are directly responsible to a criteria that you can identify a portion in the record that will help the other commissioners make that decision, please have that identified. We can still have general discussions, but we're going to make it a lot shorter, at least if I'm the chair. Commissioner Jaworski and then Mills.
Yeah, could I at least suggest that we not be redundant, that if we do come back, we don't start with the same things all over again that we just talked about? I'd like to hear other specifics. Thank you.
Mr. Chairman, this is for the public as well as for people here that already know. We've been spending a lot of time, and the most recent additions to this, the record is right there.
Yeah.
The most recent documents we've been asked to review and be familiar with are 600 pages. And I'm sympathetic to your request, but I want to remind you that I know I've spent a considerable amount of time on this, and I'm not as specific as I would like me to be. But part of it is the volume of work we've been given to do in a relatively short period of time. That's the end of my whining. So,
no, and I totally agree with that. I think that it's just for me, it's helpful if we can say this helps me get to this point where the criteria was met or was not met. And then we can, because if we change things, there are going to have to be findings. I'm going to go to staff now.
Yeah, I was just going to point out that actually next Monday is a holiday, so there's not going to be a meeting at that point. The next meeting that you all have scheduled is Tuesday, May 30th, and that's an evening meeting at 6 p.m., and that's a continuation of these discussions. I don't see anything in the schedule right now that would allow for any kind of follow-up after that before the deadline of June 8th. So you'd have to finalize your recommendation on that meeting on May 30th.
Couldn't we have it the following Monday, which would be before the...
There's currently no meeting scheduled for that following Monday. You'd have to add a meeting to do that.
That's what I'm suggesting, that we add it so it's there.
Yeah.
Yeah.
Yeah, I suggest that you do that, because if you make, we can ask, depending on what you're given to work with on Tuesday, and if you make significant changes to whatever that is, I mean, we're going to need to put the final decision in front of you before it gets signed. So I think you might need to reserve that time.
Okay.
What did you mean by Tuesday? You lost me.
Tuesday, May 30th is when you resume for deliberations. Is that what I heard?
That's correct.
Meeting, yes.
That's your next meeting.
Tuesday evening.
Yeah.
That's when you're resuming these deliberations.
Yeah.
Here, is that at
That's right.
6 or 7?
It's Tuesday, May 30th at 6 p.m. in this room.
Okay. And just a quick poll of the commissioners that are here. If that's scheduled for 2 hours?
We didn't have an end time, but
There's
that
no
would be a
end
good
time.
time to discuss.
Is the commission okay with no end time on that one?
Midnight's good to me.
Well, no. Yeah, okay. I'm just saying,
We can bring sleeping bags.
no, I'm just,
I also want to point out, Commissioner, if I could, that staff intentionally front-loaded the difficult issues
Right.
that relate to this. Like, you're going to get to a point with most of the remainder of these don't relate to the new evidence, so presumably you'll make the same decision based on the record that you did before on those that don't relate to the safety of Oakley. So
right.
it's not that daunting.
Yes. So, okay, with that being said, we will see you all a week from tomorrow at 6 o'clock
6 o'clock, that's correct.
here. Thank you. Meeting's adjourned.